Hi everyone, I'm Marley. I'll be your host for this evening. Welcome to tonight's Wednesday webinar with the Property Law Alliance. With me, I have Bruno and Silna. Welcome, guys.
Hi, Marilee.
All right, but let's get to it. There's a lot of news articles going around regarding the regulations of level 3 and 4 being unconstitutional. Now, what is the story behind that? I don't know, Silna, do you want to take this one?
Yes, so this is, it was one of those things, Bruno, I think you'll share my sentiment. Just the moment you think the day is over and you think, oh, wow, okay, it was chaotic to get into the new level 3 regulations and all the questions. And just when you settle in on a Tuesday evening, the next moment your phone goes wild and you're like, what is hitting me? And everybody's like, oh, the regulations are unconstitutional. So I had to very quickly last night get my hands on the full judgment. And I will be honest, I only read it this morning at like 3:30 because I just didn't have the energy for that last night. And it was obviously a bit of a shock to see these headings saying the regulations are unconstitutional. But going through the whole case, it's something very something I'm very excited about. And the only reason I'm excited about this is and the court specifically decided a few things. The court said, first of all, the declaration of the national state of disaster is rational, was rational, and is accordingly 100% constitutional, and that's all good and well. So that's like this one starting point. I love it to have something that we can say, okay, cool, we can start there. We know this was rational, we know this was legal, and we're all happy about that. But then what is the unconstitutional part? So Bruno, I think we want to have the conversation and just explore section 36 a bit more. But just to paint the picture, and then I'm going to throw the section 36 ball to you again. So the thing about unconstitutional is, I think a lot of people have a very skewed perception of the Constitution. The Constitution is a very, very big piece of legislation. I once printed the Constitution like on A4s, and I remember it printed a pack like this thick. I honestly can't even tell you how many sections we have in the Constitution. Bruno, do you have any idea?
No, sure.
We're not good. No, there's no way. There's like a lot. The Constitution deals with everything from our national anthem, our public holidays, how our judges are appointed, how our members of parliament are appointed. Everything about the running of the country goes into the Constitution. So the particular part of the Constitution that we are concerned about in this particular situation is Chapter 2. Chapter 2 of the Constitution is the chapter dealing with the human rights. So this is, for instance, Section 11, the right to life. Section 25, your property ownership rights. Section 26, limitation of evictions without a court order. All those rights, your right not to be unfairly discriminated against, all those rights that we are seriously fighting for, our right to freedom, all those kind of rights, they sit in Chapter 2 of the Constitution. And so Section 36 is the section that deals with limitation of these rights, because we are allowed, government is allowed to limit some of your rights in specific circumstances. But one of the tests for the validity of limitation of constitutional rights is there must be a test of rationality. So you have to see if this is the outcome we need, and these are the rights that we are limiting. Is there a rational connection between these things? So some of the issues that was brought before court is, for instance, the closure of beaches. So the argument was, why can't people go onto beaches? However, remember, the 1st of May when the entire Cape Town ended up on the promenade between 6 and 9 in the morning. So the conversation was around, if the rationale is to keep people far away from each other and to stop the spread of COVID-19, what makes beaches different from a promenade, for instance? So it's a very interesting thing. So what the court decided is there are specific regulations that they found constitutional and just, and these regulations are Regulation 36. This is the regulation limiting, well, not limiting, specifically criminalizing and avoiding illegal evictions. We are only allowed to do evictions in terms of court order. That's not really anything new for us, but anyway, that one stays. Regulation 38 being the regulation on prohibition of initiations. Then regulation 39.2D, which is the opening of nightclubs. 39.2E, am I correct here, Bruno? You're nodding, which makes me think I've got the right number.
Yeah, 39.2E is casinos. Yes, you're right.
And casinos, and then regulation 41 being the closure of our borders. Those regulations, the court said, happy with, they can see the rationale behind it, they are constitutional. The rest of the regulations, the full rest of the level 4 and 3 regulations was found to be unconstitutional. However, the court specifically gave the Minister of Corporate Governance, Minister Nkosazana Dlamini-Zuma, 14 business days, so pretty much 21 calendar days, to provide the court with an explanation on the rational thinking behind these regulations. The court may then decide, no, you know what, we're cool with this, it makes sense, we then are fine with the limitation of the rights. Or the court can say, well, Minister, back to the drawing board, let's revisit the regulations. But the court very clearly said to now move and to just disregard these regulations could potentially lead, and the court's words, and I'm quoting the court here, was could lead to an unprecedented disaster. So it's really not that the court said, no, go wild. You go buy cigarettes wherever you want, you smoke, you go braai at your friend's house. That's not what the court said. The court said, Minister, please come back in 14 business days and come explain to us what the rational thinking is behind it. So until then, all the regulations are in place. Bruno, wow, I said a lot. I said I'm going to ask you to talk about the limitation of rights. So now I'm going to stop talking and drink my coffee.
Look, I think you actually explained it quite well. It's in summary, maybe just to break it down even further. Ultimately, everyone has a right in terms of the Constitution. And we live in a world where our personal rights, as our human rights as individuals, are paramount. But now we need to bear in mind that it's not always possible to balance your rights against those of somebody else. And there's a lot of questions through the history that has dealt with human rights and conflicts in human rights. So, I mean, one of the first ones as a country, as a new democracy we dealt with, was obviously the death penalty and how that was going to be looked upon on a balance of rights, and whether somebody still has a right to life, and whether you can use Section 36 in order to limit that right in certain circumstances. And like Silna mentioned, the test is it reasonable and justifiable in an open and democratic society, and taking into account like concepts like human dignity and the like. So in the case of regulations, it does make sense that this is a massive human rights, it's not to say infringement, but it impacts human rights drastically. So the consideration, and again, us as a country, we've always been very, what's the best way to describe it? We've always taken a lot of pride, or we have legislation in place that requires that any decision that's made has some sort of administrative rationale behind it. So a president can make a decision. There's some things that's in the president's discretion, that's in Parliament's discretion, but all these things are subject to some form of administrative review. And again, we're looking at a situation that goes, great, you've got Section 36. You can limit people's rights, but why? What is the reason for it? And I mean, I suppose the one that we're all most familiar with was the banning of cigarettes, because no one really understood why that actually happened. There was no real reason. We understood the alcohol and no one understood the cigarettes. And now obviously going to level 3, it's becoming more and more important to have an understanding as to why certain things aren't allowed and what's the reasoning behind it, whether we should be in this to begin with, and whether the restrictions of human rights, especially like if you think about it, like the hairdressers and, you know, some restaurants and takeaways, or not takeaways, but the restaurants, they are struggling. So we do need answers to this. And I suppose this is a show on how democracy works. It's still in place, but it's been challenged and the courts are now reviewing it. And hopefully in 14 days, we're going to get answers.
You know what I love about this? I said that I published a short article today as well on this. And one of the things I said is what I love about this particular case is we don't have to, in South Africa, sit and moan about things. Our courts, and I must say, this is why I have the world's respect for our Chief Justice Mogoeng that specifically said, guys, from lockdown, we can lock down everything, but we cannot lock down our courts. And he specifically said, our courts must remain open to challenge the regulations. And that's absolutely gorgeous because we have a separation of powers. And government, being the legislature, and the judiciary must be completely separate. And we are seeing this, how many cases have gone to court and how many judges have said, listen, ministers, whoa, let's explain, let's get, it's not, they should never be something that could lead to anarchy. But what we have is, we can also never be in a position where you have this dictatorship type thing, because our courts are always there. And I love this because our constitution is there. And even if you do not agree with a decision from a high court, you have the appeal process. And then you obviously have the right to go to the constitutional court to address these things. And they are open and they are functioning. And this, I must say, especially if we look at other countries, I must say this makes me, this sets me at ease. I don't want to point fingers to any other countries, but I must say when I look at the world news, my sentiment is, well, thank goodness we live in South Africa with our constitution and our separation of powers, because our courts are doing a fantastic job. Our government is trying their very best in unprecedented times, and at the same time we have a court to balance these things, because Section 36 is there to balance rights. So I don't often bring Lady Justice into a conversation, but I'm going to, because remember the whole thing about the scales. I don't know if you have a scale close to you there, but well, you will always see on attorneys' websites or letter everywhere where there's something about law, is the scales, because remember the rights has to balance. Say, for instance, government has a very, very difficult job to do here, because on the one hand, people does have the right to life. So as much as COVID-19 might not seem to be fatal for everybody that contracts it, it is factually fatal for a lot of people. So now you have to balance people's right to life to people's right to freedom. Which right weighs heavier? Your right to economic freedom compared to somebody else's right of life? Suddenly it gets very complicated. And to be honest, Bruno, if I was one of the ministers, I would have been very sad if I had to make these calls, because just for me in business, I mean, it's difficult to make these decisions. But it is quite comforting to see that our courts are applying the obligations they have to separate the powers. I'm quite comfortable that we're going to see some clarity in the next few days.
No, I totally agree with you. And it's actually quite funny because I also spoke about this the other day, and it's incredible to see, especially considering the criticism of the judiciary in so many other countries where decisions are made based on what the politicians would actually require. South Africa, our jurisprudence, our history, I mean, even if you go back all the way to Rome and Roman Dutch, we have so many different principles that we look at, and to get that balancing act, judges, our courts are in that position. Our courts have shown and proven that they're able to deal with these questions, balance an act by government versus the needs of the many, against the needs of the few, and it's constantly come into play. So yes, we complain about our judiciary. We say that things take really long, that it's expensive. Maybe some of our courts aren't in, in the conditions they should be in. But the reality behind it is they're functioning. They're functioning. They're doing what fundamentally they should be doing.
Yes, and I think that's so comforting, eh?
Okay, perfect. Thank you so much for clarifying that. And now I want to ask once again, are evictions allowed? We've been getting that question a lot. So I just want clarity on that specifically. Bruno, I don't know if you want to take this one.
No worries. So since our webinar last week, not much has changed in the eviction sphere. We have experienced new things as relating to court dates and issuing of applications, that sort of thing. But the position is still as follows. Evictions are allowed if permitted in terms of the regulations. The specific regulation does provide that a court may order. As we explained last week, the difference between level 4 and level 3 is actually quite a bit, because now the court may as opposed to the court shall. And all that means is under level 4, there was a greater onus on us as the applicants to convince a court to give us an eviction order. Now there's a lesser onus. But short of that, there is still a restriction on evictions, because if the court doesn't think or deem it appropriate that evictions be carried out over this period, they won't allow for it. What that means fundamentally is you can go to court, you can apply for an eviction order, you can even have the matter heard, and you can have a court order in your hand. But the actual removal of someone from the house, that can't happen at this moment unless the court specifically says, thumbs up, to go for it.
Marilee, you know what's interesting about Regulation 36 is exactly as Bruno said, that's the whole explanation, and that's practically what we're seeing. I mean, we've had a few matters in court already, so that it's working, Bruno, and you too. I mean, everything's flying, well, sort of flying, but yeah. We'll talk about the sort of flying just now. But what I see causes the confusion, Marilee, is mostly the heading of Regulation 36. Because the heading is prohibition of evictions. Now, the thing is, Regulation 38 is prohibition of initiations. There's a whole story under that. Under evictions, it says prohibition of evictions, and it says evictions are prohibited unless it is in terms of a court order, in terms of SRP. Commercial evictions has been granted all along. It's a simple reivindicatio. So it's very interesting that something as simple as a heading in a regulation could be so misleading that people believe no evictions may be granted. We all have obtained eviction orders. Execution is a bit of a challenge, but there's really no prohibition of evictions per se. Illegal eviction has always been illegal, and this is in terms of Section 26 of the Constitution.
Absolutely. And I think
it's very important.
Yeah, and we mentioned this last week as well. This prohibition now comes with 2 sub-regulations, and the first sub-regulation also speaks about some sort of general prohibition. But I think the consensus last week was that they're referring to evictions, and they specifically, and there is mention about illegal evictions as well. So the reasoning is that evictions specifically around illegal evictions, are prohibited unless you have a court order. So one needs to bear in mind when attorneys use the word eviction, we're always referring to lawful evictions. We're going to court for an eviction. We don't say we're going to court for a lawful eviction. It's implied in our mind, but these regulations see eviction as a lawful, unlawful, it doesn't matter. It's an eviction, it's the removal of somebody. If you can do it lawfully, 100% go for it. But an eviction unlawfully, not allowed. And that's, I think, the point that they were trying to make. It just confused everyone because we're more used to it being unlawful versus eviction. They kind of confuse the terminology in terms of PI. So I can understand people's confusion.
Exactly, because let's be fair, Bruno, if you and I are having this conversation, we will typically talk about spoliation versus eviction.
Exactly.
Spoliation is an illegal deprivation of possession, a lockout, a disconnection of utility supply, moving random people in with them, all the illegal evictions. But we won't even call it an eviction because I agree with you. You explained it perfectly. I like that.
Okay, fantastic. And the next thing I want to ask you is estate agents. What do they need to operate during this time? Have they been fully operating since Monday, level 3? Do you have any insights regarding that specifically, Silna, maybe?
Yes, so I was very happy to see the estate agents back and operating. I must say it warmed my heart. I saw a lot of photos of estate agents getting ready, and they had like these boxes and boxes filled with PPE and everything. Is absolutely gorgeous. I actually have goosebumps as I say this. I was very happy to see all of them back. But yes, as long as you remain within your district. So now we just need to break it down a little again. The regulations refer to province. So we have 9 provinces. Look at me. This is since I've been homeschooling. I can now do
Geography
this. I can even tell you which the 9 provinces are. I can do long division after today. So that's a whole new level for an attorney. But so the regulations talks about provinces. Obviously, that's the 9 provinces, and then talks about municipal area. That's obviously your city or town, and then districts. So in your smaller towns, so now I'll give this away. I grew up in Middelburg. In Middelburg, if you are from Middelburg and we start talking about districts, everybody's just going to be like, huh? What do you mean now? It's like one thing. This is a municipal area. It's not really a lot of districts in there. If you look at, for instance, Johannesburg, where I am now, how many districts do we have in Joburg? I can't even begin to think. And you can accidentally cross a district line in Johannesburg, in Cape Town, in your bigger metropolitan areas without knowing that. And then also at the same time, hotspots. Moving in and out of a hotspot is, for very obvious reasons, a risky situation. If you have an area where COVID-19 is spreading at a much faster rate, obviously the risk of the people in that particular area to be positive for COVID-19 and to potentially spread it to another area that is not as heavily infected is obviously much higher. So what the regulations are trying to do is to obviously spread the curve of the virus, curb the spread of the virus. That is the intention here. And if you move within a district, that is fine, and you do not need a permit to do that. If you move, if you're a tenant or a property owner, purchaser, a seller, and you move within a district, you do not need a permit. If you're going to cross a district line to move, to view a property, to do anything, even a district line, you do require a permit. These permits can only be issued by a magistrate's court or by the police. We've had people go out and see how that is done, Bruno. At Randburg, they have the forms, at Randburg Magistrate Court, they have the forms ready, and there's a magistrate sitting ready, social distancing, everybody is lacquer, and he grants the orders. But he does like a bit of a questioning. So just heads up to everybody. If you're not planning to move, but you want to go have a braai with friends, At the magistrate court, they're going to ask you what's happening. And at the police, the forms are there as well. If you don't want to use those forms and you want to have your own form, this is Form 6 in terms of the regulations that was published on the 28th of May. So those forms are available. If you look back on our webinar on Thursday, the day after the Level 3 regulations was issued, we did make the regulations available. Or you can attend to a magistrate court in your district, and you have to attend to the magistrate court in your district. So you will have to have your home address on that, and please take your ID document with you. You will get your permit issued and you can move around. For estate agents, you're going to get your permit from CIBC, and your employer will then issue a permit for you, and you can move around to do your functions. Viewings are allowed. Please adhere to social distancing and safety protocols. And I must say, Bruno, I don't know about you, but I've been saying a show house is definitely a bit of a stretch. I'm all happy with this show house if the people come and visit by appointment, but to have a normal open house where you have 3 families suddenly, so I mean, you're not going to be able to limit the amount of people in terms of the regulations on gatherings and things like that. And at the same time, the risk of spreading is very scary. I want to tell a quick story, Marilee, if I may, just to demonstrate this. I had an estate agent call me and said, we had a tenant that has to move out. Tenant just tested positive. And we've had people that, so the lease agreement was ending at the end of May. And the tenant only tested positive, I think, on the 29th of May. But there's already been 3 people that viewed the property in that time. Okay, so now we have, that tenant can't move, because obviously the tenant that now tested positive can't move. That tenant has to stay put in that property. 3 people that viewed that property, the estate agent, all the people the estate agent's been in contact with is now in 14 days isolation. Guys, I know we want to get moving, and I know we want to get back to how things were. We can't go back to how things were. This is the new normal, and we're gonna have to make peace with the fact that this is not regulations. This is a virus that if you get into contact with that, we have to isolate, and we have to make sure that we don't infect our loved ones. So a show house, unfortunately, does pose a greater risk. And remember, if you do take people for viewings, social distance, use the necessary PPE, always keep your mask on. I know people don't like wearing a mask. I don't like wearing my mask either. It really smudges my lipstick. It's really a disaster. It's a pain, and you don't speak comfortably, but at the same time, it's not a scarf, and it's there for a very good reason. So if we want to keep our businesses open, we have to think about this as wisely as possible, because we need to get this economy going again. And to do that, we need to make sure that we keep ourselves and our clients and our staff healthy.
No, absolutely. So just to bring back to what we were chatting about, because it's actually been quite interesting, some of the questions that I have, because it's very confusing, especially considering that certain people fall under different parts of the regulations. So there's different levels of compliance. So what you mentioned now was specifically the moving across district lines, across provincial lines, across municipal lines, and the specific permits necessary for that. So that's one thing. But now, for example, as an estate agent that's conducting a service, that estate agent also then needs to have the necessary paperwork in place in order to be able to function as an estate agent. And that needs to be, and that's an affidavit needs to be commissioned. So now they fall under 2 different sections. So it's the economy must move forward, get your affidavits to say that you're working. If you're moving across lines, permits, you also now need to bear in mind hotspots like Silma mentioned. So now there's a lot that a person needs to think about. So the first thing that I warn against is we've become very complacent as to taking advice, because we've almost felt that level 5 had a certain amount of things to consider. Level 4 now applies, and everyone can now step into level 4, and it's okay how we approach it. The rules apply across the board. Now, level 3 rules apply across the board. And technically, it's not true, because the estate agent down the street from me would only require 1 document versus the estate agent possibly 3 blocks away from me, because he's across the line. And now he needs to come over, so he needs something else in order to be able to. So that's just something to be very, very mindful of. But now let's take it up a notch, because I've gotten then a lot of questions from purchasers, and specifically guys wanting to buy properties, because I'm also very much in the investment space. A lot of my clients are investors, and them coming going, I want to go view these properties now. What do they need to do? Do they need permits? Do they need affidavits? What is the situation with them? And again, it goes back down to what we just said. So you are technically a consumer of these services, and nothing that I've seen requires any consumer to go out necessarily and get an affidavit or a permit. But obviously it needs to be within the district. You need to comply and go only within the area that you're allowed to go within. If you're going to move outside district areas, municipal areas or provincial areas, you still need to follow those requirements irrespective of whether you're a consumer or not, because now you're moving across lines. And this applies not only in the property industry, but all industries. We do need to be careful to make sure we're just covered. But to answer the question of purchases, you can view properties. I don't know if you agree with me, Solna, but I don't think you need anything to view a property except proof that that is your intention, and it's an allowable service that's being provided. So you're not doing anything wrong and you're not crossing any lines.
Within the district, right?
Yes, yeah.
Yes, 100%. It's like you don't need a permit to go and buy groceries at Woolies.
Exactly.
You don't need a permit to view a property in the district. 100%. And that's been my advice to people as well.
No, that's perfect. And then just this, then the second point, also something that you touched on that's so important is, great. Now you come to lawyers, and people expect lawyers to give the black and white answer to everything, right? So is it right? Is it wrong? Tell me what the law says, so I know so I know what to do. Then I've got clients that come to me looking to sidestep the law. So we try and find the line. There's a specific gray area, and that's the area that they want to work within. The problem now with the regulations is, let's forget the black and white. Let's forget the gray, because the problem is that these regulations are there for an actual reason, and trying to sidestep them might not actually be to your benefit. So to come and say, oh, but if I approach it like this, do I really? Yes, do it. Why? Because maybe show houses are allowed. Maybe they're technically allowed. No one says that you can't have 2 families in a place at the same time. But think about it, right? You've got a listing. You've got, so one listing, expose that listing to someone with COVID, expose all your other potential purchasers or your potential tenants to another family that might have COVID. You're now exposing your entire listing. And this applies all around. This applies to sales, applies to rentals. Whether it's allowable or not is questionable, because I still feel it's a huge risk, like Silna said. But even if it is, do you really want to take that chance? Because now you get exposed. You go back to your office and you expose your office. So next thing you know, you're responsible for shutting down the branch of the agency in that specific area, just because you wanted to shove a room full of people. As opposed to a situation where you're very meticulous on how you approach, how you speak to these people, how they view the property, the steps that you take to make sure that that maybe nothing gets touched, that they do viewings, they move out the property quick enough, that there's actually cleaning that takes place afterwards. And you do it in such a way where you mitigate the risk. Wouldn't that actually work out better? Might be a little bit more effort, but you know what? I've been working now with a lot of people. There's a specific company like Rumu, for instance, but there's a lot that do great virtual tours. So they do digital tours all over the place. People are now buying properties without even going to see the properties, because everyone's worried about COVID, but they still want to invest in properties. So guess what? These tours are beautiful. These tours take pictures of everything. And then all you potentially need is to send a property inspector there at the same time, make sure that the condition is good. You like what it looks like. You don't even go there. So have these tours out there, market, make sure that you limit it to the best 2 tenants, and then take them to the property, show them the property. Hopefully one takes it, and you've just limited yourself the hassle of having to deal with 20 people at a show day or 20 individual appointments. It's just an idea. It's more practical law as opposed to law by the very word.
I agree with you, Bruno. And I think this is going to be the moment where it's going to open the door to pre-qualified buyers and pre-qualified tenants.
Yeah.
Why risk your health and everybody around your health when you haven't qualified the buyer? I mean, we know all the bond originators and most estate agencies does have the ability to do pre-qualifications for buyers and tenants. And I agree with you. I didn't even think about it until you mentioned it now. It makes 100% sense to pre-qualify and make sure that you don't do the 1.5 million viewings and people aren't even going to put in an offer they just bought. I didn't say that.
It's crazy. It's crazy the perception that we've always had throughout the years, and I think this, like this COVID pandemic, has really been able to throw us back to such a degree that we can actually now start molding different perceptions. So I totally understand why estate agents couldn't do it in the past. Because imagine a tenant comes and says, "Hi, listen, I'm very interested. I want to see that property," and you tell the tenant, "Send me your bank statements right now." It's unheard of. If I was looking for a property, I would be very apprehensive and probably move on somewhere else. But perceptions have slowly changed now. People need to understand that we are approaching things differently. We're at an age where we don't want to waste time. We're in a situation where COVID is a risk. So now if a person phones and says, "I'm very interested," they almost expect to be pre-qualified before being able to do anything else. So great, I don't mind showing you the place. I'm going to make sure you can afford it. I'm going to show you the very basics so we can get all that little nitty-gritty detail out the way, and then I can show you the property, because that spares me a lot of effort and it avoids you having to go to a property and possibly getting exposed and regulations being contravened and somebody else getting sick.
Okay.
Yeah, I agree with you.
Thank you so much. And the moving of tenants is also commercial tenants, correct? Not only residential. The same rules apply.
Exactly the same rules.
Okay, perfect. Then we had a question from one of the viewers. She asked that, can a landlord keep a penalty for breach of contract? I had a pay cut. I can't afford my duplex due to my pay cut, and there is new tenants available immediately. Don't know, Solna, do you maybe want to take this one?
Yeah, I almost just want to rephrase the question first, because a penalty for breach of contract would mean, so breach of contract means you have not complied with one of your obligations in terms of the contract. So typically, when we talk about breach of lease agreement, obviously the first one we would think is non-payment of rent or non-compliance with the house rules or the conduct rules or something like that. I don't think that was the question, but I'll answer it just in case it was. A penalty for non-payment, so a penalty for late payment, this is a fun one, guys, is in residential property not allowed in any way, shape or form. This is in terms of the unfair regulations to the Rental Housing Act, Regulation 6.1. I'm going to lie on which subsection there, but Regulation 6.1, I think it's about C or D-ish, thereabouts. Does not allow any penalty. No, I'm wrong there. I think it's Regulation 4. It does not allow any penalty of any sort other than interest in terms of the Interest Act, which is 2% per month or to a maximum of 24% per annum. That is the only thing you can charge. Nothing more than that. No late payment penalties, no nothing. Don't think that was the question. Bruno, do you agree with me? It feels more like this question was an early cancellation. So
that's a good point. When I first saw the question on the group, I had actually assumed it was exactly what you were saying, which was there's a late payment penalty, which resulted in a breach. But now that you mention it, they do speak about a retention, don't they?
Yes, retention of the deposit. And she says, and there was a new tenant found immediately. So I'm suspecting the question is more around early cancellation, because she said she can't afford the rent anymore as a result of retrenchment. Am I right, Marilyn?
Yeah, that's how I
Yeah.
understand it. Yes.
No, that makes a lot of sense. Yeah. So it's early cancellation fee in terms of the CPA.
Yes, so the lease agreement will deal with that. If the lease agreement is silent on an early cancellation penalty, the landlord still has a right to claim the actual damages that he suffered. So you will have to go back to your lease agreement and read what it says about early cancellation. If it says, for instance, the landlord would be allowed to claim a certain amount, or 1 month or 2 months rent or whatever, the landlord may only claim the actual damages that he suffered. So if you say there was a new replacing tenant found immediately, the landlord can't hold you responsible for any damages. However, if the lease agreement allows for an administrative charge or the marketing fee or prorated commission, those are actual damages that the landlord suffered, even with the new tenant being placed. And based on the provisions of your lease agreement, the landlord will be limited to the provisions of the lease agreement, but he will definitely be allowed to claim the actual damages that he suffered from you, even if the lease agreement, or I almost want to say, even more so if the lease agreement is silent on it. Do you agree with me there,
Yeah,
Bruno?
absolutely. Look, the whole point of the penalty having to be reasonable again comes into play. And you can see in our law, our legislation, case law, that we keep mentioning reasonableness of these kind of penalties. And no one can actually try to set something in stone that simply is not reasonable. So this tenant moved out immediately. There's a very good chance, or a very good argument to make, that retention of the whole deposit seems to be unreasonable. Well, it would be unreasonable unless, for example, there was commission that was paid to an estate agent, like Silna mentioned. Now think about it. The guy had to go out, pay an estate agent extra money that he wouldn't have had to pay, and now he paid it. That would, of course, be damages. So I entirely agree with you. So the retention of the deposit just as a retention of a deposit is probably unlawful. But if there's a proper explanation for it, different story.
Perfect. Thank you for answering that. Then, is there anything from your side? I think that is about the time we have for today. I don't know if there's anything you want to point out at this stage.
Just maybe tomorrow. Tomorrow we've been invited to do a talk for SA Property Investors Network. So we'll probably have a bit more discussion over these topics. And who knows, maybe tomorrow there'll be a bunch of extra stuff to discuss. So that's between 1 and 2. There's always stuff to discuss. So it's probably going to be a completely different conversation tomorrow. But we'll see.
Where is it, Bruno? On Sapin's page, hey?
Yes. Yes, it would be. Yeah, it is.
Yeah, live on Sapin page. I think we've shared the link as well, but we will. Thanks.
Yeah.
Yes. Yeah, we did share that. All right, perfect. Then everyone keep safe and warm and have a lovely evening. Then, yeah, we'll see you next week for the following Wednesday webinar and also tomorrow.
Awesome.
All right.
Thanks, Marley.
Okay.
Thank you, guys.
Bye.
Bye-bye.